Hi, everyone. As per the introduction, my legal focus is both in the blockchain space as well as in the privacy space. I'm going to be focusing first today on privacy as a constantly moving legal landscape, not only in Canada, but everywhere else as well, particularly in Europe and now out of California, and how those changes will impact us here in Canada and what that means for upcoming reform of Canadian laws, which is presently underway. I anticipate sometime after the election. So, brief overview. Actually, you know what? I think I'll skip this because I've got now 20 minutes to go through a presentation which I usually deliver in about 6 to 7 hours to a full crowd of lawyers. Maybe a bit detailed for the next 20 minutes that I have with you. So I'm going to be skipping and skimming a lot. I hope you don't mind. But this entire presentation is available at www.smartblocklaw.com. And I get into the real nitty-gritty if you'd like to take this to your own legal counsel, or if you'd like some insight into questions you may want to ask your legal counsel after this presentation. So the legal resources we have online are a currently large compendium in the works called Big Data Law in Canada. It's an 11-part series. I believe the most comprehensive in Canada. That's going to be a free access public resource. And then various blockchain related issues. Again, I think for today, maybe we'll skip the blockchain stuff. And we can get to that afterward if there's time, but for now I'll focus on big data. And of course the various offshoot legal articles under all of these guides. Okay. So eventually, big data law in Canada, just to give you an overview of this entire area, because we're not just dealing about privacy, we're dealing about data governance overall. We're dealing about, obviously, the jurisdictional issues in privacy, which is separate from privacy law per se. We're also dealing with legal standards in cybersecurity, obviously breach planning, and litigation. But then it gets kind of fun. Then you have to deal with castle issues, so that's not new. The stuff after that kind of is. The right to be forgotten and the right of erasure, that's new and emerging in Canada and all over the world. And transborder data flows and data localization issues. Nobody used to care about this stuff until it started to matter, which is now very recently. And government surveillance has now become a big issue because as of a few months ago, we've got new government bodies now specifically empowered to initiate cyber attacks, if you can believe it. That's not the term that's used in the legislation, but essentially that's what it is. And then there are specific issues that arise from artificial intelligence with respect to privacy. And while I was writing this guide, I thought that antitrust and competition would be, kind of a side issue. No, that is in fact a huge issue. It's taken me more than a month to get through that material, but that will be discussed as well. And then, of course, digital authentication as a moving target because there's new regulations coming in that sphere also. Quick disclaimer, this isn't a legal opinion. I'll leave it at that. If you want to look at this entire slideshow later, I'll leave that to you. Right now we're at slide 9 of 163. So again, if you want to read on your own afterward, I encourage it. So privacy, where do we begin? Let's start with the legislative landscape, and then we'll deal with proactively planning for breaches and reacting to breaches. Now, I'm not going to be talking about the technical aspects of these topics because that was already covered by Gary right before me. I'll be talking about the legal requirements, in particular the new legal requirements that not a lot of mid-size to, small to mid-size enterprises know about. Third-party risk I'll briefly touch upon if we have time, although I believe that was discussed. And then, of course, defending against or prosecuting a breach, because a lot of this area of law is really split into two categories. One, how do you plan for a breach and what happens before, and then what happens afterward. Digital authentication, I'll briefly touch upon that if we have time. Data residency, same as well. And the rest of it, artificial intelligence and CASL. So first of all, I want to emphasize that this is not an area of law that you should be trying to practice on your own. My materials online are comprehensive. I say that with great pride, but it's not something that you should try to formulate your own legal opinion about. Part of the reason is because of the jurisdictional messiness of this area of law in Canada. So for example, we have PIPEDA, which is federal private sector, largely private sector legislation, and then the provinces have their own privacy legislation. And sometimes they interact with PIPEDA, and sometimes there's no overlap with respect to a particular legal issue. Very helpful to hire a lawyer to help you navigate. But it's not just a jurisdictional problem. In Canada, we're also dealing with sector and industries. So within each province, there may be different privacy legislation in health, or in financial and investment, or in the public and private aspect to however your enterprise operates. So, and of course, there's criminal provisions as well. So needless to say, there's a patchwork of legislation that needs to be considered. Not only that, you should be able to look at other jurisdictions and extrapolate from them what our rules are going to be, because our federal private sector legislation is in a state of reform. The federal government has indicated an intention to reform PIPEDA. So in anticipating what that may look like, you'll probably want a lawyer that's observed the trends globally on what's happening in Europe and what is currently happening in California to anticipate what's going to happen all over Canada. And why is that important? That's important because you want to have a uniform set of operations across all of your operations. Across all of the jurisdictions in which you operate in. That's important because it will greatly affect legal cost if you have to hire different lawyers in every single jurisdiction to tweak your operations every time there's a small legislative change. I'm going to forget about the statutory torts for now. Wonderful topic. We'll save it for another day. Also common law rights of action, because of course privacy law doesn't just end at statutory issues. There's a whole bunch of torts, which is judge-made law as well in this area, and that's constantly evolving too. Now, I'm sure you've heard this a million times. The question is never whether you will be breached. The question is when you are breached. It's just a matter of time. And protection from data breaches is always rooted in trading, proactivity, internal to the entity, and continuous reinforcement of your systems through upgrades and patches. A formal breach plan, of course, is also important for reasons that we will get into. Now, I am mindful of the time. According to the clock, I've got 8 minutes until I lead a panel up here. So again, let's try to get through as much as we can in the time available. So the immediate objectives of a breach plan are to identify and document operational risk, particular to your organization. That's simple enough. I don't think it's said often enough, but that is that's my view of what a breach plan is for. And it's also to develop risk-mitigated approaches to data collection, use, disclosure, and other compliance issues across the board. Now, once again, those are the immediate objectives. The ultimate objectives are to minimize delay when there is a breach. Again, obvious. Not so obvious to maximize the effectiveness of your reaction to the breach. And then on the legal end, to minimize liability for the breach and to minimize damage caused by the breach. And of course, damage refers both to damage, to people that have sustained damage, and also damage in terms of your liability in law. I'll skip this. This is more detail. Now, something that's not known broadly enough, in my view, but seems to be catching hold, is that there's a new rule as of November 2018, and it deals with mandatory reporting of all security breaches. The larger corporations tend to be becoming aware of this through their GCs and Privacy Council. The smaller organizations, from what I gather, are not as aware of this rule. Notwithstanding my observation, however, the Privacy Commissioner of Canada has observed as of, I think it was March or April of this year, that mandatory breach reports have come in 5 times more since the enactment of this rule. Why do you want to comply with that legislation? Well, for one, if you fail to comply, there's a fine of upwards of $100,000. That's a good enough reason. When do the breach requirements kick in? Assuming you don't have internal counsel, the test is Roche, really, whether there's a real risk of significant harm to an individual. And when you do meet that standard, here are the things that have to happen. You have to notify the individual as soon as feasible upon discovery of the breach. A notification must be given to any organization or government institution that could help. The breach must be reported, of course, to the Privacy Commissioner, and the breach record must be disclosed to the Privacy Commissioner. Now, here are some things that I haven't written but are equally important. That language there, as soon as feasible, is not the same language that you'll get in Europe. In Europe, I'll have to get the exact language, but it's a higher standard. So that needs to be taken into consideration, because you'll obviously want to comply with the highest standard for all of your privacy issues to simplify your compliance plan across the board in all jurisdictions. And with respect to the last point there, the breach record must be disclosed to the Privacy Commissioner. Here's a tip. The breach record, depending on how you treat it with your counsel, preferably before the breach happens, may be subject to solicitor-client privilege. So there are certain situations in which a breach record may not be disclosable to the Privacy Commissioner because it would offend solicitor-client privilege. This is something that I would encourage every corporation to explore with their counsel, again, prior to a breach. And more on breach records, but I'll let you read that separately. I'm going to condense all of my third-party risk because I've got now 4 minutes. I'm going to condense it all into one statement, which is if you are using a third-party vendor, and if they get breached, the question is not who the breach happened to. So in other words, the breach did not happen to the third-party vendor effectively. Effectively, the breach happened through the third-party vendor. So what does this mean? That means that you, the primary custodian of data, are responsible for the breach of your vendors, which is why privacy impact assessments and audits are important throughout the data governance lifecycle. Now, obviously, if you've got a breach, it can spawn legal action under statute, common law, in a variety of jurisdictions. I'm going to leave it at there for now, again, not bog this down too much. One set of principles that I find helpful is Microsoft's 10 immutable laws of security. It's very old at this point, I realize, from 2000. But it's written so generally that I find it's still applicable today. And given that the privacy regulators in all jurisdictions, while they've given guidance on what standard must be met for active cybersecurity implementation, there's no prescribed standard that applies across the board. So if you are a startup, for example, and you're trying to get a handle of a number of issues aside from cybersecurity, and this is the furthest thing from your mind, I would keep at least these 10 laws in your mind. They're helpful as a starting place. So I've got more information here on litigation. I'm going to leave that alone. Keep in mind that if you have cyber insurance, that's probably another thing that you want your lawyer to have a look at, because there are cases where insurers will try to take an off-coverage position. I haven't noted it in the slideshow, but there's a case called Mondelez versus Zurich, and that's an international case where Zurich, the insurance company, took an off-coverage position. So this happened. This case dealt with the NotPetya ransomware attack. And Zurich, the insurance company, said, this was actually an act of war. It is not covered under our policy. We aren't covering it. Now, in that case, they weren't dealing with a cyber policy, but nonetheless, the point is that insurers have an interest as well, not to pay or to take off coverage positions, particularly when a lot of money is involved. So have your counsel really scrutinize that cyber insurance policy. It's very important when you eventually do get breached. I'll skip over digital authentication. I don't think we've got that kind of time. Data residency as well. There's a lot of movement in this space. I won't discuss it too much because it will be discussed ad nauseum in my upcoming publication. It is also discussed in a fair amount of detail in the slideshow. I'll just state that when data flows from one country to another, whether it's for processing or it's for storage or what have you, there is an international set of laws that will now apply. So agreements are soon to be in place between Mexico, Canada, and the US, the USMCA. That will cover the transfer of data. There are also agreements between us or Canada and the Pacific region, and yet more international treaties coming into force. On top of that, we've got the Privacy Commissioner in Canada now resigning to the fact that this is a very complicated area, and so they're waiting for Parliament to give them more guidance on how to deal with cross-jurisdictional data flows. So whereas in yesteryear nobody really cared about this issue, it's now becoming a hot issue in international law and should be paid special attention to in terms of your cross-border operations. And I will note that there is an increasing trend for many jurisdictions to have data residency requirements. And so that means that processing and storage of the data happens within borders. Again, not a problem of yesteryear. It's a problem that's creeping up now, and it will get worse in the future. I'll pause for a second because I think I'm over time here with... We've got 5 minutes? Great, okay. Okay, there's a lot I want to say about artificial intelligence, but I can't get into all of it either. I'll just say this. Artificial intelligence largely relies on training data. And when you're using data that contains the personal information of other people in one form or another, you've got to ask whether or not privacy legislation is engaged. And that is something, again, that hasn't been paid enough attention to in years past, but is now creeping up as a problem. So all of your training data, who owns it? Where is it coming from? What are you allowed to do with it? How can you do more with it? These are questions I think every corporation today should deal with because it will become an issue one way or another in the years to come. We're seeing that right now with Facebook and Google and the antitrust actions against them and Apple and all the big data companies in the States and out of Silicon Valley right now. This is not very well known publicly, although it should be, but recently there was a directive that came out in Canada that permitted administrative decisions to be made by an AI. there's a directive that directive prescribes how the algorithm must operate in rendering a decision and how the appeal structure must work. That should be paid attention to not only in the public sector, also in the private sector, because in my view, this is only foreshadowing what's going to be coming in the private sector. So CASL, very briefly, CASL is about commercial electronic messages. I think everybody here in this room would know what CASL is. How it operates is another set of issues, obviously. One important thing to note at this stage is that there are no private rights of action presently available under CASL. So if there's a mass email that goes out to a bunch of people that did not give their consent to get those mass emails, no class actions are coming under CASL. However, there are private rights of actions that may come under CASL, which means that you still could be sued in tort in a class action in a variety of jurisdictions. So that should be kept in mind. And all the rules in CASL are prescriptive to give you a general baseline standard for how to avoid those private rights of action. And with that, we now arrive at blockchain legal issues. I've got a few minutes, I think, now to introduce the topic, so I think that's all that I'll do right now. So blockchain, what is a blockchain? From a tree-level perspective, a blockchain is a network that keeps track of digital assets. Blockchain networks require nodes. So in other words, they require servers. Not that different from how the internet works right now. The proliferation of data across all of those nodes involves the transfer of data across borders. Again, obvious. This, in turn, will impact the cross-border data transfer issues that I previously referred to, but I'm not going to go into that right now. With respect to privacy law, well, let me back up. So a blockchain, as many of you may know, is an indelible publication of information to a variety of nodes on the internet. Once it's written, it can't be undone. And there's beauty to this, but there's also danger in privacy law. And this requires a significant amount of planning to fix this problem or get around this problem from an operational perspective. But the idea is that if you are writing personal information or other sensitive information to the blockchain and it can never be erased, well, you're probably running afoul privacy law, particularly the principle that requires the right of erasure in a variety of jurisdictions, as that right is emerging, and the right for users to update their information or withdraw their consent to have their information used. So that's an area between blockchain and privacy law that has not been adequately addressed. It will become a hot button topic, I assure you, as blockchain becomes a more mainstream technology. Are the other panelists here, by the way? Otherwise, I'm happy to keep going. Okay. So while you collect them, I'll continue on. And note that blockchain right now is in the process of rule generation in multiple jurisdictions. But right now, there's no international framework in place, and blockchain activities are right now patchwork regulated, much like privacy, except with sorry, do we have everybody here? I see shuffling. Okay. the key takeaway that I tell all startups in this space is that it's unfortunately impossible right now to optimize early market share and regulatory compliance. So what does that mean? Either you're going to be first to market, or you're going to be focused on compliance, but you really can't have both. That really is the truth for any privacy law venture as well, but it's even more true in blockchain, where there's a dearth of regulation, and we know they're being drafted, and we can probably anticipate what they'll be, but they're not here yet. So in other words, you have to be comfortable with taking risk in the blockchain space. You should also get counsel to optimize your risk across borders, because again, not only are there privacy laws that are implicated that are different in different jurisdictions, but that's the case times 20 in the case of blockchain technology. So right now I'm cycling through a roadmap of my usual presentation. Actually, this part of the presentation alone I've given in Dubai to help them with their crafting of their blockchain rules. And this presentation on its own took 6 hours over 2 days. Obviously, I won't cover all of it, but suffice it to say it's a very complicated area of law, potentially even more so than privacy, if you can believe it. And I think I better stop it there, because otherwise I'm going to get carried away and we're going to get really into the guts of the beast, and we'll be here the whole day.